community assistance team. We are recording these and it'll be added to the housing toolbox after the session today. Again, I'm Shelley with MHP. Thank you for joining me. I'm here with my colleague, Emma McGurran, who is helping with this session. And as you likely know, we've had a series this month of a few different sessions. We started with looking at housing trust funds and CPCs and their roles and working together. Last week, we heard from Amherst and Marshfield sharing about their experience with their trusts, establishing goals and strategies. And today we're digging into the open meeting law in Massachusetts. We had an abbreviated session on this with the AG's office last spring, and we were actually impressed with how much people were engaged with the topic and asking questions. And so we decided to invite the Attorney General's office back to do a little bit more extensive training on open meeting law, and particularly how it pertains to our local boards like housing trusts and community preservation committees. So we've invited the AG's office, and Liz Carnes Flynn is with us today. She is an assistant attorney general in the Division of Open Government at the Massachusetts Office of the Attorney General. And I'm going to turn it over to her in just a minute, but I'm wanting to remind you that if you have questions or comments, please be putting those in the chat, and we'll be monitoring those. Your comments and questions, we'll be bringing them forward, and we'll try to get through hopefully all of your questions today. At this point, I'm going to stop sharing my screen, and I'm going to turn it over to Liz, and thank you so much for being here with us today.
Great. Thank you so much, Shelley. I'm really excited to be here with everyone, and we'll see if I can smoothly transition to sharing my screen. Hopefully that worked for everyone.
Looks great.
Excellent. Awesome.
Looks good.
Wonderful. Well, thank you for the introduction, Shelley. As Shelley already noted, my name is Liz Carnes Flynn. I'm in the Division of Open Government in the Attorney General's office, and we interpret and enforce the open meeting law. So that's why I'm here with you all today. I will just note, since this is being recorded and will be shared later, that obviously the information I'm sharing today is current as of today. I can't speak to 5 years down the road whether this will be current, but certainly as of today it is. Also, more than happy to answer questions. And as Shelley noted, I think you can put that in the chat, and then we'll sort of pause throughout and answer questions. But basically what I can provide is general guidance and advice. We can't provide an advisory opinion about a specific situation. So if you ask a really specific question, I might have to just sort of answer in a more general way, but just want to make everyone aware of sort of those parameters before we get started. And then without further ado, I will jump right on in here. And I guess just one last caveat is this is a more extended presentation than the one that my colleague Carrie did in the spring. However, it is still abbreviated from our full standard 90-minute training that we give usually about twice a month. We have a free webinar. So if you are looking for additional training on the open meeting law, certainly feel free to sign up for one of those. They're open to the public, they are free. And we also have lots of resources on our website. So lots of places to get answers about the open meeting law. And hopefully this is a good start for everyone. All right, so first of all, we just do like to cover sort of, the overarching purpose of the open meeting law. Why does the open meeting law exist? And it's, it's a transparency law. So the legislature is trying to balance sort of government accountability and government efficiency here. And so on the accountability side, there are requirements to post a notice of meetings of public bodies, to hold public body deliberations open to the public at publicly accessible locations, to create and maintain accurate minutes, those types of transparency concerns. And then on the other side, there is government efficiency. And so the legislature recognized that there might be some circumstances in which a public body needs to hold certain discussions in private, at least for a period of time, and maintain the confidentiality of records related to those discussions, again, at least for a period of time. And so that's what we refer to as executive session. And I will talk about that a little bit during this presentation later on. So for anyone who is a member of a public body, hopefully this certification form looks familiar to you. If it does not, please visit our website as soon as possible after this training. This is something that needs to be filled out within 2 weeks of taking office. And basically it's certification that you've received certain open meeting law educational materials. So that includes our open meeting law guidebook, which also includes the law itself and our regulations. and also a copy of any determination that was issued in the last 5 years in which we found that your public body violated the open meeting law. So you should receive those materials upon taking office. They should be given to you, by the clerk or some other designee. You would then complete the certification form and give it back to the person who gave you the materials to begin with. If you haven't seen this and it doesn't look familiar, go to our website. You can find the form. You can also find all of that information I just mentioned, the open meeting law guide, all of our determinations. And then if you need further assistance, just reach out to the division and we can try and get you on the right track there. So just some sort of quick overarching, sort of if you take nothing else away from this training, these are the basic elements of the open meeting law. So as I already mentioned, notice must be posted for all meetings. Meetings must be held open to the public unless there is a lawful executive session convened. Minutes must be kept for all meetings. That includes open session and executive session meetings. And then finally, there is a complaint process. So if someone feels that the open meeting law has been violated, there is a process for filing a complaint and having a determination made as to whether the law was violated. All right, I'm going to jump into the nitty-gritty. I guess I'll pause here just to see if there are any general questions, because I feel like I went a little fast there, but then we're going to dive into some definitions.
So I don't see any general questions, but just so you know, your microphone is kind of coming in and out a little bit.
Oh, okay. I'm sorry about that. I feel like my connection in this office is unfortunately not great. So let me know if it continues and I can try and move to a different section in the office. I'll also try and kind of sit closer to it. All right, great. So you can see here the definition of public body. So that's obviously very important. The open meeting law applies to public bodies and individuals who are acting as public body members. So what is a public body? A public body is a multiple member board, commission, committee, or subcommittee, however created, elected, appointed, or otherwise constituted, established to serve a public purpose. And then the law specifically notes that a subcommittee shall include any multiple member body created to advise or make recommendations to a public body. So we see that pretty frequently. Public bodies are constantly creating subcommittees. Those subcommittees are still subject to the open meeting law. They kind of become their own public body. So they would have their own quorum. They would have to post notice for their own meetings, keep meeting minutes, all of that good stuff. I will note here, there is an exception that was created by the Supreme Judicial Court in a case called Connolly v. School Committee of Hanover, which asserted that when a public official, in this case a superintendent, creates a group to advise that individual on a matter that they have sole authority to control and make the decision about, then that group is not going to be considered a public body subject to the open meeting law. And sort of the logic there is that the individual is not a public body. They are not subject to the open meeting law. So the fact that they create a group to help advise them on a matter that they could just go and do, not subject to the open meeting law, then that group is also going to not be subject to the open meeting law. So these are kind of the factors that we consider when we get a complaint and we have to determine whether a body is a public body subject to the open meeting law. We look at whether the body is within government and not excluded from the law's definition of public body. There are certain entities that are specifically excluded from the definition. We also look at whether the body is empowered to act collectively. So a group like a focus group, where it doesn't have a set quorum, it's not a set number of individuals, it's just sort of, hey, everyone come share your thoughts and opinions about a particular project. That's not going to be a body that's empowered to take any collective action. It's more just sort of information gathering. And then, is the public body established to serve a public purpose? And the example we use here is, the retirement party planning committee is not going to be subject to the open meeting law. They're not serving a larger public purpose. They're just planning a party. So these next definitions are really, really important. And I feel like we come back to these a lot. A lot of the questions that we answer in our trainings kind of come back to this definition of deliberation. And I will note that it's a very broad definition. So the open meeting law defines deliberation as any oral or written communication through any medium, including electronic mail, between or among a quorum of a public body on any business within that body's jurisdiction. And then I'll just note here, for purposes of the open meeting law in general, a quorum is a simple majority unless there's some other law or establishing provision that sets some other number as the quorum. But in general, it's going to just be a simple majority of the public body's members. So then you can see here with the definition of meeting why the definition of deliberation is so important, because a meeting is defined as deliberation by a public body with respect to any matter within the body's jurisdiction. And there are some exclusions that I'll discuss quickly, but I just want to kind of note how those pieces fit together. So if you have a quorum or more of a public body discussing matters within that public body's jurisdiction, that's deliberation. Deliberation is a meeting. Notice must be posted for meetings, meeting minutes must be kept, so on and so forth. So that communication between or among a quorum of a public body triggers the obligations of the open meeting law. So that's why that definition is such a fundamental definition in our work, and why we often come back to that whenever we're confronted with questions or complaints. So as I noted, there are a few exclusions to the definition of meeting right in the law. I'll note very quickly, state quasi-judicial boards, if they're meeting to make a decision in an adjudicatory proceeding, that's going to be excluded from the definition of meeting. Town meeting is excluded from the open meeting law. So those are pretty quick. Then you have these other three: on-site inspections, events, and attendance at a meeting of another public body. So basically what's going on here is the open meeting law itself says, okay, a quorum of a public body can show up in these instances. They can show up at an on-site inspection. They can show up at a public or private event. They can show up at a meeting of another public body. However, there's a caveat. Those members cannot deliberate, so they cannot communicate between or among a quorum on matters within their jurisdiction while in these other settings. So basically it's saying that the mere fact that a quorum of the finance committee happens to show up at the select board's meeting does not all of a sudden turn that into a meeting of the finance committee. Everyone's still a member of their community. They still get to go witness other public bodies hold their meetings. But there is that strong caveat that they not deliberate while they're doing so. I think probably most relevant here would be the on-site inspection exception. And again, that also includes that caveat of not deliberating while performing an on-site inspection. So we've kind of come down to three options that public bodies have with respect to on-site inspection. One would be to have a quorum of the public body attend the on-site inspection and really not communicate at all, not ask questions, not make comments, just kind of go receive information and then hold a properly posted meeting that's open to the public. And then at that location, ask questions, share thoughts, share concerns, all of that good stuff. The other option is if the location is open to the public and accessible to all members of the public, including individuals with disabilities, then the public body could choose to just post the on-site inspection as a meeting and hold it as a full meeting, go ask questions, share comments, all of that good stuff. And then finally, the third option is to have groups of less than a quorum kind of go on the on-site inspection. Then you're not worried about deliberation between or among a quorum. And then again, at a later date, hold an open meeting that's properly noticed and all of that stuff. And then at that point, a quorum of the body could discuss the on-site inspection. And just a quick note here about sort of meetings that aren't meetings, just because sometimes these do confuse members of the public. So we've found that abutters meetings with the developer, there's no public body involved in that. So that's not going to be a meeting subject to the open meeting law. Informational meetings facilitated by municipal staff, sort of for the same reason, not going to be subject to the open meeting law. Public presentations, so that's just information is just being shared out to the public. And also community forums. Again, it's not a public body itself. It's just meeting and sharing information or maybe receiving concerns and questions from the public. So those are some gatherings that are not meetings under the open meeting law that sometimes confuse members of the public. All right, I'll pause here just to see if there are any questions before we get into meeting notices.
So there are a couple. One is, what are the consequences of violating the open meeting law?
Sure, that's a good question. It really depends. So I'll talk at the end about our complaint process. There is also a judicial complaint process. But we have authority if we find a violation to order remedial action, and that can include, it really depends on what the violation is, right? It could include ordering a public body to amend its meeting minutes because they're insufficient. It could include ordering a public body to release executive session minutes if they, did not properly hold the executive session. We can nullify action. I will say that that's pretty rare that we do that, but that is something within our authority. We could nullify an action that was taken in violation of the open meeting law. So yeah, it really we oftentimes will order training, so order a public body to attend a training like this, but it really depends on what the violation is that we find.
Thank you. So we have someone asking, can minutes be written? Oops, I just lost it. Written or recorded?
So I will talk about meeting minutes later, but I will just say that, right, minutes do need to be written, and a transcript not only is not required, but also does not comply with the requirement to summarize the discussions that were held. So it does need to be written minutes summarizing the discussions that were held, as opposed to just a video recording of a meeting is not going to satisfy the requirement to create minutes.
3 minutes. And then someone is asking, if it is a committee, can a committee chair appoint an advisory group to advise just the committee chair and not the full committee? And then would that be outside of open meeting, or does that person not qualify as like a public official? Does that make sense?
Good question. Yeah, I think it makes sense. I think it's probably too specific for a general answer. It would really depend on the facts and, what authority the chair had, and whether that would be viewed as the public body creating that committee, in which case it would be considered a subcommittee. But that would be really fact dependent. We would have to dig in and see exactly what happened and what the group was asked to do and by whom.
Great, thank you.
Sure.
So is the role of a chair or a support is it the role of a chair or only a support administrator to share out information to committee members? Is one of these prohibited from sharing out information? So the chair or a support administrator sharing information to the full committee?
Sure. So it's really, that is a good question. And I think we cover that a little bit more in our full presentation, I will say. So definitely come to one of our other trainings as well. Again, this is kind of going to depend. There is an exception to the definition of deliberation for the sharing of like scheduling information or reports or documents that are going to be discussed at a meeting. However, there is a very important caveat with that, which is that no opinion of a public body member be shared. So it's going to be really fact dependent on what was shared, by whom, and sort of for what reason. So and again, if we come back to that definition of communication between or among a quorum regarding business within the public body's jurisdiction, we have said that a public body cannot use a third party to communicate in a way that the public body could not itself. So you couldn't have the chair say, I want to share my opinion about this matter that's within our jurisdiction. I'll just ask the town administrator to share it for me. We would say, no, you can't use that third party to do something that you yourself could not do. However, if the chair or the town administrator wanted to share a report that was written by some other person who's not a member of the public body, and the sharing of it is just for discussion at the next meeting, then that would likely fall within that exception to the definition of deliberation. I hope that is helpful.
And then one more before I think we should move on is someone's asking you to please comment on serial deliberation, electronic or otherwise.
Sure. Yeah. So another great question. You guys know your stuff already. This is wonderful. So, right. So serial deliberation is where basically a quorum of the public body is reached in a non-contemporaneous manner. And so that, sort of a simple example would be board member A and board member B have a conversation. They're not a quorum, so that's fine. That's a subquorum. It doesn't meet that definition of deliberation. But then board member B goes to board member C and says, here's what A and I just discussed. And now that's a quorum. Now they've reached 3 members. So obviously for my scenario, it's a 5-member board. So we would say that's serial communication. And we do see that come up frequently in the case of using email. So we do advise caution for public bodies using email, especially if it's not within that narrow exception to the definition of deliberation for just simply scheduling a meeting or saying, here's a report for discussion at the next meeting. If public body members do start to kind of get into the substance and share opinions, or even not sharing, it's not, the definition of deliberation is so broad, it does include non-opinion communications. And so you can see that happen in email. So we advise caution because sometimes people don't even intend to do it. They just accidentally reply all or accidentally forward something. So just, you want to be careful when communicating about board business via email.
That's great. I think you can continue on. Thank
Awesome.
you.
Thank you so much. Thank you for your questions. These are really great. So you'll see up on the screen here, meeting notices is the next topic. So notice needs to be posted for every meeting 48 hours in advance of the meeting, but that 48 hours excludes weekends and holidays. So you do want to be mindful if you're scheduling a meeting for a Monday, a Saturday and Sunday don't count towards that 48-hour period. So just keep that in mind. I will talk briefly about emergency meetings, but in general, the rule is 48 hours prior to the meeting, notice needs to be posted. And meeting notices need to include these specific topics. So the date of the meeting, the time of the meeting, the place of the meeting, or that access information if it's going to be held remotely, and a list of the topics that the chair or any other individual who's responsible for making the notice anticipates will be discussed. So that's pretty important. And I think that's an area where we see some public bodies get into trouble a little bit is they don't reasonably list the topics that the chair or the individual who's creating the notice anticipated for discussion, or they're not listed with enough specificity to really advise the public, right? So a topic such as new business or old business, that doesn't tell the public what you're intending to discuss or what you anticipate discussing. So I like to remind public bodies here that the audience for your notice is the general public who is maybe not necessarily familiar with what you do. So that's, you're telling those people when you're meeting, how they are accessing your meeting. So are they accessing your meeting remotely? Are they accessing your meeting at town hall? How does that individual member of the public gain entry to your meeting? And then you're also telling that individual, again, someone who may not be familiar with your general work, what you anticipate you're going to discuss at the meeting so that that person can say, yeah, I'd like to go. I want to hear what they're going to say about this topic. And then finally, the notice does need to include the date and time that the notice was posted. So as I noted, there is an exception for emergency meetings. The public body should still post notice as soon as possible, but if there is an emergency, then the public body is relieved from the requirement to post notice 48 hours in advance. However, I just want to note that emergency is pretty narrowly construed, so it has to be an unexpected event that really requires immediate action. That means action that cannot wait 48 hours. So, one example I like to give is in the early days of the pandemic, we would have, let's say a school committee wants to hold an emergency meeting to discuss what to do about the field trip scheduled 6 months from now. And they would say, well, the pandemic was unexpected. Yes, the pandemic was absolutely unexpected, but there's no immediate requirement to address the field trip that's happening in 6 months. That can wait 2 business days to discuss. So you really have to have both pieces of the puzzle there. In terms of posting meeting notices, hopefully everyone's pretty familiar with this procedure, but I'll go over quickly. Sort of the default rule in the open meeting law is that for local public bodies, notices are posted with the clerk's office, and then they are posted somewhere on or in the building where the clerk's office is located that is accessible and visible 24 hours a day to all individuals, including individuals with disabilities. And then the alternative, if the municipality has adopted its website, is that notices would be posted on the website. Notices still need to be available at the clerk's office during regular business hours, but if a municipality, has adopted its website, then that would become the official notice posting location. So if we received a complaint about notice not being, say, timely posted, we would look to the official notice posting location. So that's either a physical notice posting location or the website. And I will not go over these ones too much because I think we're probably dealing mostly with local public bodies here, but there are similar but slightly different posting requirements for regional and county bodies, and then also for state public bodies. We do get some sort of common questions, as you can see here. What if a new topic arises after notice is posted? So the open meeting law, as I noted before, requires that notice be posted 48 hours in advance, and that notice include all of the topics that the chair and anyone else creating the notice reasonably anticipates will be discussed. So sometimes, as you can imagine, something comes up 24 hours before the meeting or comes up at the meeting. And we have said that the public body can discuss or even vote on a topic that arises after that 48-hour period, even if it's not included on the notice. We encourage public bodies to postpone the discussion and include it on a meeting notice if at all possible, just because that gives the most notice to the public of what's going to be discussed. A public body can also choose to amend its meeting notice. So let's say a topic arises and it's, 24 hours before the meeting, the public body can choose to amend its meeting notice, and that just gives the public as much notice as possible. If that's the case, if a meeting notice is amended within 48 hours of the meeting, then the amended notice needs to include the date and time that the original notice was posted, as well as the date and time that the amended notice was posted. What if the clerk can't post notice in time? It is, ultimately the public body's responsibility to comply with the open meeting law. So we just encourage public bodies to work with their town clerk's office, know their hours, know when they're going to be closed, and make sure that you get your notice to them in plenty of time to get posted 48 hours prior to the meeting. And then finally, canceling a meeting. The open meeting law doesn't speak to canceling a meeting at all. So there's no requirement to post notice that a meeting has been canceled. However, we certainly advise as a best practice and common courtesy to the public, just if you've posted a notice, posted a meeting, and then it's going to be canceled, posting some information that the meeting's going to be canceled just lets people know not to, hire a babysitter and come to town hall during a time when no meeting's going to occur. With respect to meeting notices on a website, we just want to note that notices should be easy to find. So, a central calendar page, I think works best, but you could also post it to each public body's individual page on the website. But it should just be something that's easy and intuitive for the public to know, here's where I go to find meeting notices. We do suggest that public bodies avoid posting notice in multiple locations unless you're going to have it all linked back to the same document. Sometimes we see confusion where a meeting notice in one location was updated, but another meeting notice wasn't, and then the public's confused about what's going on. If the website is the official notice posting location and there is a website outage, the municipality has 6 business hours from the time that the outage is discovered to fix the outage. Otherwise, any meetings that are within 48 hours of that would need to be canceled and reposted for 48 hours after. So just to note, hopefully everyone's at this point aware of these temporary provisions that we've been under since the pandemic. And so basically what the temporary provisions do, and they are still in effect right now until March of next year. So we'll see what the legislature does in terms of, as we get close to that date, what action they might take. But what the provisions do is, instead of requiring that a public body hold a meeting at a physical location that is accessible to the public body can instead require that the public access the meeting remotely through Zoom or, conference line, through live streaming on cable access, those types of things. And then the other thing that the temporary provisions do is they allow all or more than a quorum of public body members to participate in a meeting remotely. So prior to the pandemic, prior to these temporary provisions, a public body had to hold a meeting at a physical location that was accessible to the public, and the person chairing the meeting and a quorum of the public body was required to attend the meeting in person. So those two requirements public bodies have been relieved of having to comply with those 2 requirements under the temporary provisions. So with respect to accessibility, just want to note that if you are going to require the public to attend a meeting remotely, that remote access needs to be adequate, and it needs to give the public the ability to clearly follow the proceedings of the public body as those proceedings are occurring. So it's not sufficient to just video record a meeting and then post it online later. The public has a right to attend the meeting, even if remotely, to attend the meeting live as it is occurring. With respect to whether your meeting's remote or in person, a public body does need to make reasonable efforts to accommodate a crowd. So if a larger than anticipated crowd shows up, the public body needs to make some effort to accommodate so that all members of the public who wish to attend can attend the meeting. Meetings must be accessible to all members of the public. That includes individuals with disabilities. And so we have here on the slide just some information about the Americans with Disabilities Act. And if you have questions about whether your meeting location complies, certainly feel free to reach out to our Civil Rights Division and they can provide some helpful guidance. With respect to public participation, just a note that the open meeting law, as I've sort of already discussed, gives the public the right to attend a public body's meeting. However, it does not give the public the right to address a public body. We certainly encourage public bodies to allow for as much public participation and public comment as time and circumstances provide for. However, the open meeting law itself does not provide a right to public comment or otherwise publicly address the public body. And if someone does end up disrupting a body meeting, if given a fair warning, well, first of all, so the chair would need to advise that person that they are disrupting the meeting. And if after a fair warning and a fair opportunity to comply with that warning, an individual continues to disrupt the meeting, then they can be asked to leave and they can ultimately be removed from the meeting so that the meeting can go forward and the public body can continue conducting its business. The open meeting law does provide a right to any individual to record an open session meeting or otherwise transmit the meeting. And then I already discussed removal earlier. All right, so I'll pause here just to take a breath and see if there are questions.
So the one question that just came in is, if a meeting is held as a hearing, such as with the Finance Committee, does the public have a right to speak?
Great question. Yes. So I can't speak to public hearing questions because those fall outside the open meeting law. But you're right, there are situations in which the public does have a right to speak at a meeting, at a public hearing, and oftentimes, most often probably, a public hearing is also held at a meeting of a public body. So there may be meetings of a public body that are subject to both sets of laws. But I can't answer questions about the public hearing specific issues other than the general awareness that yes, there are times when people do have certain rights to address a public body. It's just not under the open meeting law.
Okay, great. So that's it right now.
Awesome, thank you. So you'll see here, this is a slide about remote participation. So when we say remote participation, we're mostly talking about members of the actual public body, right? So it's different from remote access to the public. This is remote participation by members of the public body. So in general, you want to, if you need to participate in your public body's meeting remotely, you would want to notify the chair as soon as possible that you need to do so. The chair does need to announce at the start of any meeting where one or more members are participating remotely, the chair needs to announce who is participating remotely. Sometimes that's the entire board. If everyone, if the whole meeting is remote, then we have said in the past that simply sort of taking roll call at the beginning of the meeting could satisfy that announcement requirement. If one or more members of a public body participates remotely, then all votes taken during that meeting need to be by roll call vote. And the roll call should be recorded in the minutes. So that's, calling a member's name, asking how they vote, and then noting down how that individual voted, as opposed to a voice vote where it's just, all in favor or all opposed. There is, you'll see here, an executive session declaration, but I will note that in a later slide. With respect to technology, it's really up to the public body what technology they want to use, but any technology used to allow someone to participate remotely needs to allow that member to clearly hear what's happening at the meeting location, and also to allow everyone at the meeting location to clearly hear that member who's participating remotely. Finally, if there are technical difficulties, it's sort of up to the chair how to address that. One recommendation would be to maybe call a brief recess and see if can kind of get that member back to the meeting remotely. However, if those efforts are unsuccessful and a member needs to essentially leave the meeting because they really can't participate, then that does need to be noted in the meeting minutes what time that member was deemed to have left the meeting because they just couldn't technologically participate anymore. And then you'll see it's just another note about the temporary provisions with respect to allowing all members to participate in a meeting remotely.
So can I just interject with,
Awesome.
because a couple of questions came out about remote. So one is, so as of March 31st, 2025, does it mean that we can no longer have participation in via Zoom or hybrid meetings?
So it's a little complicated here. Basically, I mean, first of all, we don't know what the legislature might do. So the legislature might prolong the provisions again. They've done that several times in the past. We just don't know what they're going to do. But with respect, if things revert back to the way they were before the temporary provisions, a public body can still always provide multiple methods of access to their meeting. And in fact, we encourage that. That's great. It allows more members of the public to witness meetings. So you would have to hold a meeting at a physical location, but you could still continue to stream it on local access cable. You could continue to allow a Zoom option. Certainly that's great for members of the public. Also, members of the public body could still participate remotely, but the requirement that the chair of the meeting and that a quorum of the public body attend at a physical location would be back in play.
So if the legislature did nothing, communities could still do hybrid meetings, but the quorum of the board would have to be present at a physical location.
Right, exactly, and the chair, yeah. So there would be a requirement to go back to a physical meeting, but a member of the public body could still participate remotely. I guess the caveat here, and this is what gets complicated, is under the sort of standard rules, the municipality has to first adopt remote participation for the municipality. So when the governor's executive order was issued, that sort of, that's the model for these temporary provisions. We determined that, okay, the governor has essentially adopted remote participation for all municipalities in the Commonwealth. That most likely would revert back. So there could be a question there about whether remote participation has been adopted. So just something to keep in mind if their temporary provisions do not continue forward.
Fantastic. Okay. And then one other question around remote is the idea of the issue with Zoom bombers, and someone's wondering what the AG office's kind of best practices with how you address people who are Zoom bombing a meeting that are really aiming at disrupting the meeting.
Sure. Yeah, definitely hear that. I have to say we haven't heard as much of that lately. It was definitely a big thing early days. So I'm hoping it's getting better. I'm hoping it's just, it's not just that we're not hearing about it, but in fact that it is getting better. Let's see, it's been a little while since I've thought about that topic. I know at one point we had issued some guidance. One thing, so the meeting does need to be open to all individuals. You can't sort of pre-screen and not let people in. They have to be allowed in. And then, as I noted before, someone could be removed from a meeting, but you have to give them, you have to warn them, you have to ask them to stop disrupting the meeting, give them a chance. And I know that part of the problem with the Zoom bombing is that it's happening so quickly. So one thing you could do is I think we would call it like webinar mode, where you would only allow people in and they would not be able to use their microphones or use their cameras. So there are ways to kind of use the technology to allow the public body to, you know, be projecting out. So the public is witnessing the meeting, but not necessarily letting attendees use their mics and their cameras. So that might be one suggestion.
Okay, fantastic. Thank you. That's it.
Thank you. All right. We'll get into executive session. I'm not going to go over all 10 executive session purposes. I'm just going to focus on purpose 6, which has to do with real estate. But I just want to note for everyone that there are 10 executive session purposes. So certainly feel free to check out our website if you want more information about other executive session purposes. So before a public body can convene an executive session, and just as a reminder from the beginning, executive session is a discussion that a public body holds in private. So that is not open to the public. The public does not get to witness that discussion. And so the general rule is that all meetings, all discussions are open to the public. So this is an exception to that general rule. And we do construe all of the executive session purposes very narrowly for that reason, because they're an exception to the way it's normally meant to go. So first and foremost, before a public body can convene an executive session, they still need to post notice, right? And that still needs to be a topic on the notice. But the public body must first meet in open session, because the public has a right to then witness these next steps that we're about to discuss. So the public body convenes an open session. The chair then states the purpose. Why is the public body going into executive session? So you might cite to the specific executive session purpose you intend to use. The announcement, as well as the meeting notice, does need to include sufficient information about the purpose. So for example, if you're going to discuss a piece of property in executive session under purpose 6, you would want to identify that piece of property that you're going to discuss, unless for some reason identifying that piece of property would somehow jeopardize the whole reason for holding the conversation in private. And that's really a case-by-case determination. Then the next thing that the public body would do once the announcement is made is they would take, someone would make a motion to convene an executive session for this purpose. And then the public body would take a roll call vote of whether to convene an executive session or not. That's another reason why it's important to hold an open session meeting first, is because that motion could fail. And then the public body could go on to discuss that topic, and the public should be there to witness that. So let's say you take the roll call vote and it passes. Then the chair would want to announce to the public whether the meeting is going to reconvene in open session or if the public body is going to adjourn from the executive session. And this just allows the public to know, should we stick around? Is there more meeting for us to witness after this executive session, or is this really it? Should we head home? As I noted before, members can participate in an executive session remotely. However, any members participating remotely at the beginning of the executive session have to make an announcement that there's no one else at their remote location who can hear or witness the executive session unless that particular individual was invited to join the executive session. And then finally, all votes that are taken in an executive session, and this is regardless of whether it's remote or in person, all of those votes need to be taken by roll call and need to be recorded in the meeting minutes as roll call. All right, so as promised, I will not do any of the other executive session purposes other than purpose 6. So this allows the public body to convene in executive session to consider the purchase, exchange, lease, or value of real property if the chair declares that an open meeting may have a detrimental effect on the negotiating position of the public body. So the chair does need to make that announcement as part of that open session announcement of the purpose for the executive session. And then just a note here again, I explained earlier that the purposes are construed very narrowly, and that's true for purpose 6 as well. So discussions of just general use of a piece of property, that's not going to be appropriate for executive session. It's really the point of this executive session purpose is to protect the public body, protect the municipality's negotiating position. And so that's really, there has to be a discussion of some sort of negotiation with respect to this piece of property, not just what are we going to do with this piece of property, that would be a discussion that should be held in open session. But really, what is our opening offer going to be on this piece of property? Things that could jeopardize the negotiating position if you had to let the opposing side know right out the gate what your maximum amount you're willing to spend would be, that would harm the negotiating position of the municipality. All right, meeting minutes. Any questions before I switch to meeting minutes? I want to be mindful of the time too. Looks like okay on time.
Looks good.
Okay, awesome. Thank you. So the next sort of major topic here are meeting minutes. This is definitely an important part of the open meeting law. It is a requirement for all public bodies to create accurate minutes of all of their meetings. So that includes emergency meetings, regular open session meetings, executive sessions. Any meeting that a public body holds needs to have accurate minutes created and maintained. The minutes do need to include certain information, as you can see here. So the minutes must state the date, time, and place of the meeting, and a list of the members present or absent. From our perspective, we certainly appreciate when the minutes list both present and absent members, but only one is required. Minutes must include a summary of the discussion on each topic. I'll go quickly and then I'll kind of come back to that one. The minutes must also include any decisions that were made, actions were taken. It must include the record of all votes. There are no secret ballots allowed. And anytime that there is a roll call vote, the minutes should, specifically record that roll call vote. Even if it's unanimous, it should list each member and how they voted. Minutes must also include a list of any documents or other exhibits that were used by the public body at the meeting, including any remote participants. The minutes do not need to actually attach those documents, but just need to list them. I think, probably most typically public bodies just list them at the end of the meeting minutes. And that just allows a member of the public to know what documents were the public body looking at or using at the meeting when they were discussing this topic. So with respect to a summary of the discussion of each topic, as I noted before, a transcript is not required and also technically doesn't comply because it's not a summary. But the summary does need to be sufficient enough to basically allow someone who didn't attend the meeting to pick up the meeting minutes, read them, and have a good sense of what happened and why. And so again, sort of like the meeting notice, I encourage public bodies to think about the audience. And the audience is a member of the public who did not attend your meeting. Could that individual pick up your meeting minutes and understand what took place at the meeting and what decisions were made and why? So it doesn't need to include every opinion that was shared, every comment, but it needs to be sufficient enough that that member of the public who didn't attend could understand what happened. I think that's probably the trickiest part of meeting minutes, is getting that summary of the discussion on each topic down and sufficient. So with respect to open session minutes, the open meeting law does require that a public body approve those minutes, and the open meeting law says in a timely manner, but then of course does not define what that means. So we've come in with our regulations and defined timely manner as within the next 3 meetings or 30 days, whichever is later. However, we do encourage public bodies to approve their minutes at the very next meeting. And this is just because, memories are faulty. The more time that goes by, the more likely it is that people might forget exactly what was discussed or who said what. And so it's best to try and approve your minutes as soon as possible. I already mentioned that the documents do not need to be physically attached to the minutes, but do need to be listed. In terms of a request for minutes, with respect to open session minutes, a public body does need to respond to a request for meeting minutes within 10 days. And they do need to provide those minutes, whether they are in draft form or in the final approved form. So it's not sufficient to just respond and say, the minutes are in draft form, we'll get them to you later. The public body does need to provide those if they're in draft form within 10 days of the request. If for some reason the minutes don't yet exist, sometimes we do see people request minutes like the day after a meeting, then the public body still needs to respond within 10 days, but they can respond and explain that the minutes just don't exist yet. For any other records, sometimes we'll see requests about, documents or exhibits that were used at a meeting. Those requests would fall under the public records law. And so any questions about that can be directed to the supervisor of records because it falls outside the open meeting law and under the public records law. With respect to executive session minutes, the same standard applies in terms of accuracy and summarizing the discussions that were held and recording any decisions or votes taken. With respect to a request for meeting minutes, things can be a little bit different. However, just please note that the requirement is that there still be a response provided to the requester within 10 calendar days. So from executive session minutes, as I discussed a little bit at the beginning, these can be withheld for as long as the executive session purpose remains ongoing. Once the executive session purpose has been served, the minutes do need to be released to the public. And that's true whether there's been a request for them or not. The minutes need to be released once the purpose has been served. An example here would be, let's say a public body is engaged in litigation. Maybe they meet, once a month in executive session to discuss the litigation, discuss litigation strategy, and the matter is going on for 6 months. That purpose is still ongoing. But then let's say at month 7, the litigation matter is settled and it's all wrapped up, it's done, it's been dismissed, it's no longer ongoing. We would most likely say that the executive session purpose has now been served. And so now that 6 months worth of executive session meeting minutes should be released to the public. So the open meeting law requires that a public body periodically review its past executive session minutes to see if it's maybe withholding some minutes, but the purpose has actually been served and it actually needs to release those minutes to the public. So keep that in mind. A public body should be regularly reviewing its executive session minutes that it has not released to the public to see if it does need to release those minutes to the public. We have said that a review every 3 months, once a quarter, every 6 months is going to be sufficient to comply with this requirement. But let's say you receive a request for executive session minutes. If the public body has recently performed that periodic review, it can just respond to the requester within 10 days, letting them kind of know what the status is. That could be, oh yes, these have been released to the public. Here you go. Here are the minutes you asked for. Or these minutes have been released, but these minutes are not being released because we recently reviewed them and this executive session purpose remains ongoing. If at the time of the request, the public body has not recently performed that review, then the public body does need to perform that review within 30 days or by the time of its next meeting, whichever comes first. So it can be a really quick turnaround time that the public body needs to review those minutes that have been requested and determine if they need to be released. Either way, within 10 days, the public body should respond to the requester and just let them know what's going on, what the status is. We've received your request. We have to review those minutes. We're going to do so at our next meeting, and then we'll get back to you. So that kind of covers responding to requests for minutes, but happy to answer any questions on that. Just a little note about documents used at a meeting. As I noted, those do need to be listed in the meeting minutes. However, the open meeting law itself doesn't define what used means. So we have found that sort of typically when a document is physically present, verbally identified, and its contents are discussed by the public body members during the meeting, then we're going to deem that document to have been used. And so it needs to be listed in the meeting minutes. Just a quick note here, there are 2 types of materials that are exempt from public disclosure, even if used at a meeting. That includes performance evaluations that were created by individuals who are not members of the public body, and also application materials and other application materials other than resumes. So those could be withheld even if requested. All right, one more pause before changing to the complaint process.
So it goes back a little bit because it was a question that came in right as we were transitioning, but I think it's important for you to address because of a pretty recent SJC opinion on free speech at public meetings. I think it was earlier this year or last year. So the question is, with meetings, particularly in this scenario, it's with like a Zoom kind of meeting. Could a mic just be muted if the language is considered offensive or disruptive by the chair or whoever's helping to mitigate the meeting? Could a camera just be shut off if the visual transmission is seen as offensive or disruptive at a public meeting?
So it's a good question. We certainly see it raised a lot. It is a question that falls outside of the open meeting law. I know the case you're talking about, Calenda, and basically that had to do with rights under the state's constitution. And those are issues that fall outside the open meeting law. So with respect to the open meeting law, it doesn't require public comment. Although again, we encourage it. However, if a public body is going to allow public comment, then really what you should do is kind of reach out to legal counsel to get some advice about how to handle certain situations. But those sort of situations regarding or issues regarding free speech and issues like that under the state or U.S. Constitution do fall outside of our purview. So we do decline to review allegations related to that.
Okay, great. So I guess the thing to remind is that the public comment is not required, even though it's encouraged. So with open meeting law, it's really about whether or not you're giving that space. And then if it's language that's being used, then folks just need to know to reach out to their counsel and to get broader or more specific advice on how to handle the challenging kind of situations that we sometimes experience at our meetings.
Right. Yes. Yeah. If you think about the open meeting law, it's access. It's access to witnessing the meeting is kind of the primary role that the open meeting law is playing there.
Okay, great.
Sure. Great question, though. Definitely get that one a lot. So I think the last topic I'll really go into depth here, actually it might just be the last topic in general, is the complaint process. So there are actually two separate processes, but the one I'll talk about the most is what we refer to as the administrative process. That's the process that goes through our office. So you'll see here the complaint form. This can be found on our website, and complaints do need to be filled out on this form. However, if someone has more to say than will fit in this little dialog box, you can certainly attach additional pages. It's not meant to be a limit. It's just the complaint form that we need to have filled out. So the complaint form is, the complaint would be written down in the form, and then it is first filed with the public body itself. It does not first come to our office. Sometimes people get a little confused about the process there, but it first goes to the public body that's being complained of. Once that happens, so if for a local public body, it would be filed with the chair of the public body, and then a copy is also given to the clerk for the clerk to keep for official records. Once the chair receives the complaint, the chair should disseminate the complaint to all members of the public body. And then within the next 14 business days, several things need to occur. First, the public body needs to meet to review the complaint and sort of determine how it's going to respond. Is it going to take remedial action? Is it going to write its own response or delegate authority to respond to maybe legal counsel or to the chair alone or to the town administrator? All of that is fine for the public body to choose to delegate, but first they must respond. First they must meet, review the complaint, and make those determinations. And then once that determination has been made, the public body does need to respond to the complainant in writing. At the same time that the public body responds to the complainant in writing, the public body needs to copy our office with a copy of the response as well as the complaint. If a public body feels like it's going to need more than 14 business days to accomplish all of this, you can send our division an email just letting us know what the complaint is. You want to attach a copy of the complaint, that you're requesting an extension of time, why you need an extension of time, and then how much time you want. So basically the date that you're asking to have your time extended to. And then we will get back to, we try and get back to folks really quickly about extension requests. So just if you do need more time, that is something that you can ask for. So after the public body responds to the complainant and provides our office with a copy of the complaint and the response, the complainant then has a choice. If they are satisfied with that response, then that's the end of it. They don't need to do anything else. If the complainant is not satisfied with the response, they can file the complaint with our office and request further review of the complaint. The complainant does need to wait 15 days after the date that they filed with the public body in order to then file with our office. So there's kind of a little waiting period between the response and when the member of the complainant can file the complaint with our office. One other note about timing, well, two other notes about timing. The open meeting law complaint that is first filed with the public body needs to be filed within 30 days of the date of the alleged violation. The only exception to that is if the violation could not reasonably have been discovered when it occurred. So sometimes this happens, let's say a violation occurs in executive session. Maybe members of the public can't discover that violation until the minutes are released 3 months later. So if that's the case, if the violation could not reasonably have been discovered at the time it occurred, then the complainant has 30 days from the date that the violation could reasonably be discovered to file that complaint. But either way, it's 30 days from either the date of the violation or the date that it could reasonably be discovered. All right, so let's say the complainant is not satisfied with the response to the complaint. So then they file with our office. So as I noted, there's kind of a holding period between the response and when they can file with our office. And then there is a deadline past which they cannot file with our office. So that's 90 days from the date of the alleged violation. Just a note that we will not review allegations that were not raised in an initial complaint. So sometimes we do have new allegations raised in a request for further review. We will not review those. It needs to be in an original complaint so that the public body has an opportunity to respond to the allegation. And also just a note that complaints and documents submitted with complaints that are filed with our office are considered public records. So want to keep that in mind when you're submitting with our office. So from there, once a complaint is filed with our office, this is the process that we go through. So it would be assigned to one of the assistant attorney general. So I'm one, or we have 4 others that the complaint might be assigned to. We would then review the complaint and conduct an investigation. And sort of the breadth and depth of the investigation really depends on what's being alleged, how much information is shared in the complaint and the response, and yeah, just sort of the complexity of the alleged violation. Once we go through all of that, we would issue what we call a determination, and we would either find that there was or was not a violation of the open meeting law. If there is a violation of the open meeting law, then we would order some remedial action. Most often we order immediate and future compliance with the law. And then as I noted in response to a question at the beginning, we might order that meeting minutes be released or amended, or that public body members attend a training or hold a meeting anew. Any number of appropriate remedial actions depending on what the violation was. And then finally, a public body does have a right to appeal our determination if we find that there was a violation. However, there is not a similar right of appeal for a complainant if we find that there was not a violation. There's also a separate complaint process, the judicial complaint process. So this is where either our office or 3 or more registered voters can file in Superior Court to enforce the open meeting law. If 3 or more registered voters choose to do so, our office is not necessarily involved in that process. So it's totally separate. It's in the courts as opposed to in our administrative process. All right, quick review here. Hopefully everyone remembers at the top here, there's a public body member certification form. If you are a member of a public body and you have not seen that form before, please go to our website and find the information you need there. Notices must be posted for all meetings. Meetings must be open to the public unless a lawful executive session has been held. Minutes must be kept for all meetings, both open and executive session. And then finally, there is a complaint process. And I know we'll save a little time for questions here. I just want to know you should receive a handout as well, which is basically these slides. So this information that you're seeing here about resources and our website, hopefully you have a copy of that as well. But certainly invite everyone to go to our website. It's just got so much information about the open meeting law. And then you can always reach out to our office as well. We staff a helpline where we can provide general guidance about the open meeting law. So if you have further questions, certainly feel free to reach out to us.
Great, thank you, Liz. So a couple questions at this point. So one is actually a question that I have of with the complaint process. I noticed on the slide that it said that it's considered public document, which means that the person filing the complaint would be public, where it would be known. Is that right?
Yes. So right, complaints do need to be. We will not review anonymous complaints. And then anything that is a complaint that is filed with us is considered a public record. So if someone requested that, we would provide that in response.
So do you think that that inhibits people from filing complaints because
That's
of the nature of just being on the local level and being the risk of your neighbors, your people that you're in relationship with would know?
Sure, it may. I don't know. I guess I can't speak to what motivates people to file or not file, but certainly understand your concern there. Yeah.
Yeah. So something was brought up, and I know that you addressed it early on with subcommittees, but I think it bears repeating because so many of our, particularly our affordable housing trust funds, oftentimes do have some kind of subcommittee. But the question is, if one member of the public body, the board, leads a working group that reports back to the full body, what are their obligations under the open meeting law?
Sure. So this is going to be really fact dependent. So basically the question is this working group a public body subject to the open meeting law, which is actually one of the more fact intensive questions that we get in a complaint. So it really depends on a number of factors. One, just to note a couple of determinations. So we did find in one determination that where an individual member of the public body just sort of voluntarily of their own volition said, I'm going to work on this topic. And it was just them all by themselves. No one asked them to do it. And then later, another member of the public body said, hey, I'll help you with that. We found, okay, the public body had not had an intent to create a subcommittee and no subcommittee was created. But then we also have lots of determinations where it's very clear that the public body did intend to create a multi-member body. Maybe they sought multiple volunteers to work on a project. And so it really depends on the facts with respect to how this group came to be and what purpose it serves. And if it's, advising a public body, then that would be a piece of, that would be something that we would consider that would land in the column of most likely is a subcommittee, but it really depends on how it was created and what it's doing.
Okay, that's great. And then going back to a question earlier, someone in the chat has given a little bit more detail. So in the incident of, say, a virtual meeting and someone is interjecting, but the broader public was not invited to be participating in the board meeting, they could be there, but not to be interjecting. Can that person be silenced, muted, if it's just an open meeting, but they weren't invited to speak?
Again, I think I'm going to give the caveat here of, general guidance, not legal advice. I think it depends. I don't know that we've addressed exactly that situation, and maybe we have. We've issued lots of determinations, especially involving remote meetings. So it may be that we've addressed that exact situation. But I think it's going to depend, right? If it was an in-person meeting, that person who's just, essentially disrupting, it sounds like is what's being described here. That person would be given a warning and asked to stop disrupting the meeting. And then if they continued, then they would be asked to leave. So I guess, it's a question of how analogous is cutting off someone's mic. Is that asking that, is that making them leave or not? So I think it really depends. I think it's something that we would need to think about on a case-by-case basis.
I'm wondering if one strategy, which I know some communities use, is at least with Zoom, they'll use the webinar mode where you have to be invited in to speak, where that could get around this if it's not the intent isn't to have broad public engagement necessarily, but it seems like some of these technologies have different modes where you could do it in the webinar format, and then you could invite certain people if it's appropriate according to the agenda, I guess.
Sure, absolutely, yes, and I think we've given similar guidance in the past of the webinar mode being, because again, the open meeting law is concerned with, can members of the public see what the public body is doing? Yeah, so right, and then you could have maybe someone who's there to present on a topic is allowed to speak, but in general, it's in webinar mode.
Right, yeah. I know that I'm oftentimes, when I'm at meetings, I'm invited in as on the webinar mode, so that seems like it's oftentimes used. So wanted to let folks have a minute to put their questions in the chat. If you have any other things you'd like to put before Liz this morning or this afternoon. I know that Emma, my colleague, has put a lot of links in the chat, so please look at those. I think it's to all the different materials that Liz has brought up and that we already have on our housing toolbox. But if there are no other questions, looks like maybe there aren't at this time. Oh, great. Someone is saying it was very informative, and we really appreciate your time, Liz, being here. We will be posting the materials, as Emma has already done, on the Housing Toolbox, so you'll be able to access these resources and all the different information here, the contact information, et cetera. But Liz, thank you so much for being here. I always learn more every time I see this presentation or a variation of it. And we thank everyone else for joining us today and earlier in the month. We hope that these sessions have been informative overall. And happy holidays to everyone. Thank you.
Thank you.